Hello everyone, welcome back to our channel, First View. We hope you're doing great. In this video, we're going to talk about Supreme Court in Birthright Citizenship case limits judges' use of nationwide injunctions. In a significant ruling tied to the Trump administration's attempt to end birthright citizenship, the Supreme Court has curbed the power of federal judges to issue nationwide injunctions, narrowing their scope to only cover plaintiffs directly involved in a case. If you are interested in this topic, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. The Supreme Court on Friday limited the use of nationwide injunctions, reining in federal judges' ability to issue sweeping orders that have in recent years stymied implementation of policies from Republican and Democratic presidential administrations alike. In a widely anticipated decision stemming from President Trump's executive order seeking to end birthright citizenship, the High Court said that universal orders likely exceed the equitable authority that Congress has granted to the federal courts. Justice Amy Coney Barrett authored the majority opinion for the 6-3 court, with the liberal justices in dissent. The court granted the Trump administration request to narrow the reach of the injunctions blocking the president's executive order while proceedings move forward, but only to the extent that the injunctions are broader than necessary to provide complete relief to plaintiffs who can sue, Barrett wrote. The justices did not address the question of whether Mr. Trump's order is constitutional, and the administration has said agencies have 30 days to issue public guidance about the implementation of the policy, allowing time for more challenges to be filed. Some say that the universal injunction gives the judiciary a powerful tool to check the executive branch. But federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them, Barrett wrote. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. In her dissent, Justice Sonia Sotomayor accused the majority of abdicating its role in protecting the rule of law. She read portions of her dissenting opinion from the bench. With the stroke of a pen, the president has made a solemn mockery of our Constitution. Rather than stand firm, the court gives way. At a press conference at the White House following the decision, Trump praised it as a monumental victory to the Constitution, the separation of powers, and the rule of law. Universal injunctions and the birthright citizenship case. The court's ruling came in a trio of emergency appeals by the Trump administration arising out of the president's executive order seeking to end the 14th Amendment's guarantee of birthright citizenship, which means that everyone born in the U.S. is a citizen regardless of their parents' immigration status. The Justice Department had asked the Supreme Court to narrow the scope of 3 separate injunctions that blocked implementation of the president's policy nationwide, while proceedings brought forward by 22 states, immigrants' rights groups, and 7 individuals moved forward. But instead of swiftly deciding whether to grant the Trump administration emergency relief, the Supreme Court held arguments on whether to restrict the use of nationwide or universal injunctions, which are judicial orders that prevent the government from enforcing a policy anywhere in the country and against anyone, including individuals who were not involved in the litigation before them. The dispute over the president's attempt to unwind birthright citizenship has become intertwined with the administration's battle against nationwide injunctions. These sweeping orders have frustrated both Democratic and Republican presidents seeking to implement their agendas among gridlock in Congress, and the fight over them has been simmering for several years. The Congressional Research Service identified 86 nationwide injunctions that were issued during Mr. Trump's first term and 28 granted while former President Joe Biden was in office. In Mr. Trump's second term, the Congressional Research Service found 17 nationwide injunctions were issued during the first 100 days, though the Trump administration estimated last month there have been far more, at least 40 of these orders, and most coming from the same 5 judicial districts. Some of the justices have suggested in past writings that the Supreme Court would have to clarify whether nationwide injunctions are allowed at all, and members on both ideological sides of the bench have been critical of them.
The president and his allies have attacked judges for issuing nationwide injunctions in the slew of legal challenges to Mr. Trump's policies, and even called for some to be impeached. The president's Birthright Citizenship order was one of the first that he signed on his first day back in office. While the 14th Amendment has for a century been understood to guarantee citizenship to all people born in the U.S., the president's order denied birthright citizenship to children born to a mother who is unlawfully present in the U.S. or is lawfully present on a temporary basis, or whose father is neither a citizen nor lawful permanent resident. The president directed federal agencies to stop issuing documents recognizing U.S. citizenship to children in those categories born after February 19th. More than half a dozen lawsuits challenging the measure were filed before it took effect, and 3 federal district courts in Washington, Maryland, and Massachusetts each blocked the government from implementing the order. Federal appeals courts in California, Massachusetts, and Virginia then refused requests by the Trump administration to partly block the lower court orders. The Justice Department filed emergency appeals of the 3 decisions with the Supreme Court in mid-March and asked it to limit enforcement of the Birthright Citizenship order to 28 states and individuals who are not involved in the cases. The administration said the Supreme Court should, at a minimum, allow agencies to develop and issue public guidance while proceedings continue, and took aim at the breadth of the injunctions issued by the district courts. Government lawyers said in a filing that universal injunctions have reached an epidemic proportions since Mr. Trump returned to the White House in January. Those injunctions thwart the executive branch's crucial policies on matters ranging from border security to international relations to national security to military readiness, Solicitor General D. John Sauer wrote. They repeatedly disrupt the operations of the executive branch up to the cabinet level. But the plaintiffs in the cases urged the Supreme Court to leave the district court orders in place. In a filing of their own, officials from 18 states, the District of Columbia, and San Francisco called the Trump administration's request remarkable, since it would allow the government to strip hundreds of thousands of American-born children of their citizenship while the legal challenges move forward, and render them deportable on birth and at risk of statelessness. The states argued that the Trump administration seeks to violate binding Supreme Court precedent that recognized birthright citizenship is guaranteed by the 14th Amendment. The court's decision. Writing for the majority, Barrett looked to the nation's history and said that nationwide injunctions were conspicuously non-existent in the 18th, 19th, and 20th centuries. If federal courts had such a tool, surely they would not have let it lie idle. Nothing like a universal injunction was available at the founding, or, for that matter, for a century thereafter. Thus, under the Judiciary Act, federal courts lack the authority to issue them, she wrote. In her dissent, Sotomayor accused the court's conservative majority of abdicating its role in protecting the rule of law. She read portions of her dissenting opinion from the bench. Today, the threat is birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. Sotomayor accused the court's conservative majority of ignoring whether Mr. Trump's plan to end birthright citizenship is constitutional, and said its patent unlawfulness underscores why universal injunctions are appropriate remedies. While the High Court agreed to grant Mr. Trump's request for a partial stay of the injunctions, Barrett wrote that there are still issues for the lower courts to decide, including whether narrower relief is appropriate. The Supreme Court's decision still allows plaintiffs challenging a policy to file class action lawsuits and seek certification of a nationwide class. In her dissent, Sotomayor urged individuals who may be impacted by Mr. Trump's birthright citizenship plan, as well as lower courts, to move swiftly. The parents of children covered by the citizenship order would be well advised to file promptly class action suits and to request temporary injunctive relief for the putative class pending class certification. For suits challenging policies as blatantly unlawful and harmful as the citizenship order, moreover, lower courts would be wise to act swiftly on such requests for relief and to adjudicate the cases as quickly as they can so as to enable this court's prompt review. On the heels of the Supreme Court's decision, CASA, one of the groups that challenged the order, asked the federal district court to allow its lawsuit to proceed on a class-wide basis and certify as a class all children who have been born or will be born in the United States on or after February 19th, who are designated by Executive Order 14160 to be ineligible for birthright citizenship and their parents. While the court did not decide on the constitutionality of the policy itself, the decision paves the way for continued legal challenges and class action suits as the debate over executive authority and constitutional rights intensifies. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Supreme Court in Birthright Citizenship case limit judges' use of nationwide injunction. The Supreme Court ruled 623 to restrict nationwide injunction, limiting federal judges' ability to halt policies beyond the involved plaintiffs. The ruling stemmed from Trump's executive order attempting to end birthright citizenship for certain U.S.-born children. Justice Amy Connick Barrett authored the majority opinion, arguing that universal injunction exists. Judicial authority Justice Stormare dissented, cautioning that this move undermines constitutional protections. The court approved a partial suspension of the injunction but left ongoing legal challenges in place. While the constitutionality of Trump's order remains unresolved, the agencies have 30 days to issue guidance lawsuit and class action filing against the policy content.